Give council a moment to get set up. All right, our last case for today is 25-0330. Laquadera, apologize if I'm mispronouncing that, the state. Both council ready to proceed?
Yes.
All right. Again, our default is 5 minutes for rebuttal. Is that sufficient?
Yes, Judge.
All right, please proceed.
Thank you. May it please the court, good morning. Thank you for having oral arguments on this issue. Hanny Demetrius on behalf of the appellant, Carl Laquadera. The issue before the court is, did the lower court err by ordering the forfeiture of over 200 rare animals worth in the excess of $1 million from Everglades Exotic, a 30-year-old properly licensed with 3 full-time employees, by impermissibly applying Florida statute 379.338 and was without jurisdiction to do so. Statute 379.338 does not apply to this case. The title of the statute is Confiscation and Disposition of Illegally Taken Wildlife, Freshwater Fish and Saltwater Fish. Why would the word illegal be in the title if it applies to all FWC confiscations? If you look at all the sections in this chapter, they all deal with the title and the subject matter of illegal. 379.337 deals with illegal taking of saltwater products. 0.338 is what I just mentioned. 0.3381 is photographic evidence of illegally taken wildlife, freshwater.
This seems a little different than what's in your brief.
Judge, I don't believe that we emphasize this point enough in our brief.
Did you put it in your brief at all?
Yes.
Where?
It is under the section, Judge, that says that once the warrant.
Give me a page number. Bill, I read your brief really closely. I don't remember this argument. And what you're basically saying is, even if he had been convicted and even if a sentence had happened at sentencing, right? Like these animals were just outside the scope of the statute because he didn't possess them illegally.
That's correct, Judge.
Right. So where's that in the brief?
Page 14, where we argued that the invalidation of the warrant removed these animals from the scope of this statute. So, and in the rest, it's 0.339, it's seizure of illegal hunting devices.
I'm sure the scope, I get your argument about the warrant. I'm not sure the fact that the invalidation of the warrant is the same as saying that these animals just are outside the scope of the statute generally. It just means this specific warrant was not valid. But I don't see anything in that portion of the argument about these specific animals because they weren't illegally possessed. Because the allegation here was that he was not that he illegally possessed them, was that he was mistreating them, engaging violations, and those kind of thing. It's not that he couldn't possess them, assuming he complied with the statute. But what you're saying here is this statute just wholly does not apply to legally possessed animals.
That's correct.
I don't see that in the brief.
And it additionally says, accordingly, the lower court erred in holding that 379.338 Florida statute applied and authorized the forfeiture of the animals.
But yeah, but you're saying in the brief, you're saying it didn't apply because the warrant was invalid. And now you're saying it didn't apply because these were legally possessed animals. Those seem like two completely different arguments to me.
Judge, I would.
And counsel,
I
would agree with Judge Mize in terms of my understanding of this argument that you're referring to in your brief is that you were focused on the portion of the statute that requires it to be seized under the authority. And so therefore, since the warrant was invalid, your argument was, well, it wasn't seized under the authority because the trial court quashed the warrant.
What I would say, it falls under this same heading, that it doesn't apply. And what I'm arguing today is a more nuance or extension.
Is it a completely different argument as to why it doesn't apply, counsel?
I wouldn't say it's completely different, Judge.
Is there anything? Tell me the sentence about it, the statute in the brief about the statute not applying to legally possessed animals.
Say that again, Judge.
Read me the language of the brief where you make the argument that the statute doesn't apply to legally possessed animals. I'm just telling you, I don't think it's in.
I would refer to the same sections that
give me the sentence.
directed.
Literally read it to me because I want to know what you're talking about.
There's
you can't consider arguments not made in your initial brief, so I don't want to disregard an argument that was made. But so I want to make sure we're looking at the same thing here.
It's thus is argued in the lower court, the invalidation of the warrant removed the animals from the scope of the statute because the animals were no longer seized under pursuant to 379 or any other chapter. Accordingly, the lower court erred in holding that 379.338 Florida statute applied and authorized the forfeiture of the animals.
All right, so, and your position is that encompass saying that the statute, regardless of the condition of any warrant, just doesn't apply to legally possessed animals. Your position is that that was articulated by the language you just read?
I would say this is a further, more detailed argument on that position.
Okay.
So, Judge, and it's also further articulated by the supplemental cases that the Attorney General provided, where both cases talked about illegal takings. And one of the set of facts was, here you have
Counsel, things in the state's supplemental authorities don't meet your burden to establish error, right? You're appellant. You've got to establish error in your initial brief, right? So if an argument's not in the initial brief, you know, it's often a genuine question as to what level of generality an argument must be made, right? Like, because at one certain level of generality, you could say the trial court was wrong, right? That's obviously not specific enough. On the other hand, you don't want to be so specific that somebody can never meet their burden, right? So there can be a debate as to what level of generality or specificity is required as to an argument. But whatever level of generality or specificity you apply, the argument must be in the initial brief. So the state saying it came up in the state's supplemental authority is just not relevant.
yes, that's not what I'm trying to do. Well, I'm bringing up the state's brief to illustrate the distinction between something that is a licensed product, such as these animals, and illegally taken. And I think that is the strongest argument that we have, is that here's a person who's had a license for a certain number of years and is regulated by FWC, and they come in and you have to apply, and they come in and inspect, as opposed to someone who just goes and shoots a deer without a license and takes the animal and has no permit, right? And so what becomes the remedy?
Under your scenario, though, even if the warrant hadn't been invalidated, right, and say he'd been convicted on everything, and at the sentence the judge pronounced, I'm taking the animals, that would not be valid because these animals are just wholly outside the statute, right?
Yes.
Okay. So if it doesn't depend on the validity of the warrant at all, right, how could that argument be encompassed in your argument about the validity of the warrant?
I believe when the
Is this
lower
just a
court,
wholly new argument, counsel?
again, I believe it is encompassed under that subject matter, and this is a
So
more,
answer my question. You just conceded that this argument does not depend in any way on the validity of the warrant. That if the warrant had been valid, your argument would be exactly the same.
well, I
But
don't
yet you
think,
said it was encompassed under the argument saying the warrant is invalid. Agree.
well, I don't think that is relevant, Judge, because the warrant here was invalidated. So, and that's not in controversy. And in fact, when it was granted.
I know, but I'm talking about as a matter of presentation, whether your argument was presented to us. And that means it must be fit under some part of your brief. Right? Have to have been made in the initial brief. You're the appellant. You've got a burden to show error. Right? You don't get to do that for the first time in an oral argument. And so when I asked you where that argument is, you said it's encompassed under the argument that the warrant was invalid. Right? But you then told me the argument in no way relates to the warrant being valid or invalid. And whether the warrant, even if the warrant was completely valid, your argument would be exactly the same. Doesn't that make it difficult to argue that that argument was encompassed under the argument as to warrant invalidity?
What I would answer, Judge, is this argument encompasses both sides, whether it's invalid or valid. But in this circumstance, it was found invalid and illegal, so it's encompassed.
Does the word illegal appear in your brief? It doesn't appear in that section.
It appears when discussing the statute because the word illegal is in the title of the statute.
What page of your brief is that?
And I think also the argument also falls under when we discuss in statutory interpretation of the statutes to go into the document of the statute itself in interpreting what is the effect of the statute.
All right, let's do one at a time. So you were telling me that there's a page of your brief where you discuss the legal illegal distinction. Can you just point me to that page?
I did not say that I discussed that illegal legal distinction in the brief.
Well, I said, does the word illegal appear? And then you said it's where we discussed the statute.
It's in the title of the statute, and I'm seeing if we included the title in the statute.
But you're admitting you didn't discuss the legal illegal distinction at all.
I agree that I did not.
Okay, so where was you're just trying to give me a second place that you said the argument was? You said it's
When
also
we make a
this.
discussion of how does the court interpret something that has no case law and it's in the plain reading of the statute.
So you telling us to do a plain reading of the statute just on its own, you think that encompasses the argument as to the statute drawing the distinction between legally and illegally possessed animals? Just giving us the kind of a boilerplate of use the language of the statute, that encompasses an argument as to the statute making a distinction between legally and illegally possessed animals?
The argument of looking at the statute means looking at all the language in the statute is what we argued. And in arguing that this does not apply based on a clear reading of the statute, on a plain reading.
I don't want to disregard an argument that you've made. It's not made in the initial brief. I can't consider it. So I'm trying to make sure, I'm not trying to be overly, emphatic here. I'm trying to understand. The point you're talking about is the portion of the brief where you just give the general rule, use plain language of the statute. You're telling me that kind of just general statement about how to interpret statutes, that encompasses your argument about there being a distinction in the statute between legally and illegally possessed animals?
Yes, Judge. And also in the goal of fleshing out a complex issue like this is to have the oral arguments in order to flesh out the issue further.
But if just saying that you use the language of a statute encompasses every argument you could make under the statute, like if it encompasses this argument about what the statute actually means, even though it didn't mention that argument, would that mean you could just literally come into oral argument and argue anything about the statute? Because you said, well, we said interpret it based on its language. We can argue anything about its language. That encompasses all possible arguments that could be made about its language.
So we also filed supplemental in this case, and it was Rule 68A-6.003, paragraph 3, subsection A, which gives the appropriate relief in a situation like this, which is a person who had a license and is at some point revoked and removed from the ability to own a license. That person has 90 days for the sale and transfer of those animals. And that is what applies to Mr. Laquadera, who had a license.
So also not an initial brief.
In the supplemental.
Seminole authority.
Yes. So he had a license. The seizure happened. During the pendency of the seizure, there was litigation with FWC about the license, and the license is still held to be valid until final disposition of it. And once eventually it was revoked, he should have been given these 90 days to sell or give the animal transferred to ownership to someone else. However, in this case, the court came past any type of jurisdictional deadline. 6 months after he started serving his sentence, he was never noticed that these animals were going to be seized. And now the court found that essentially timing doesn't matter, that the court has jurisdiction whenever to enter someone's sentence and then violate double jeopardy and impose an additional penalty that was never there. So at 6 months after, he loses all his assets valued at over $1 million and over 200 animals. The proper remedy should have been to follow 68A, as I just mentioned. However, in the lower court's order, the court was troubled by Mr. Laquadera no longer possessing a license. Therefore, he interpreted that to be an illegal possession. and they said that 379.338 applies. However, it does not apply because it was never an illegal takeover. There has to be a separate distinction between a person who carries a license and someone who just takes something without any authority or permission. And why would the penalty be the same for those types of situations? And that's why there is codified relief under 68A. In addition, if there was a confiscation or a seizure that was going to take place, there should be a process in everything that's done, right? Timeliness, notice, an evidentiary hearing, findings, none of that was happening. And if there's no further questions, I will reserve my time.
And may it please the court, David Campbell from the Office of the Attorney General, representing the state of Florida. I think I would first like to just ask if this court has any questions, and then I can go into what we argued in our brief.
Yeah, thank you. It seems like your argument to me relies on this not being a sentence, right? Sentencing does have to happen within a certain period of time after the conviction, and you can't do it. You can't re-sentence somebody months later. So like, just draw that out for me. Like, how is this not a sentence? Like, what you're basically saying is that this happened by operation of the law. And so that would mean that that would have to mean it's not a sentence because sentence have to be pronounced.
Yes, actually, that would be based on the brief and statute 379.338. Yes, this is something that under the wildlife statutes, some of the other statutes that were cited by appellant in his initial brief, those do outline, timeframes and stuff and procedures that have to be followed for the forfeiture.
Yeah.
Yes, but in this case, when it's wildlife, based on this statute, it's automatic. They have their due process by the procedure up to when they're being found guilty, or they decide to,
Can you say that about any conviction? Like, so say a statute said if someone's convicted, upon conviction, they shall be sentenced to 10 years, right?
But this
And
is,
so-
I'm sorry.
Right, or they shall be remanded for 10 years in prison, whatever, right?
Yes.
You wouldn't say that the state could just wait 5 years after and say, put them in jail for 10 years, like the sentencing, there's rules as to sentencing that have to occur, aren't there?
Well, yes, but in this case, as I said, we're distinguishing wildlife. And as it even says in the statute here, it doesn't even have to happen upon conviction. It can happen or sooner, forfeiture of the animals. In this case, wildlife forfeiture can happen sooner. It doesn't even have to happen upon conviction. And our interpretation of that is if there was a hearing or evidence presented to the judge, to the court could find that, yes, these animals need to be forfeited for their own well-being. And I believe that goes with wildlife. Wildlife are sort of under the protection and ownership of the state of Florida, unlike we're domesticated animals. Therefore, the state is ultimately, in charge of their well-being. So that's why in this case, because of
Are you
wildlife,
saying people can't own wildlife?
no, they can, but it's almost sort of like
It's a property,
guardianship or
right?
something for them. It's almost like by the grace, yes, you can have this, you can have this animal, you can take care of it, you can even have a business with it and stuff. But ultimately, if it's a wild alligator or something, by you owning this, you've also gotten a permit for it. And by getting the licenses and permits to possess certain types of animals, you've then agreed that FWC can come in at any time. So it's a little bit different. It's not quite 100% ownership. You get to, by grace, have these animals. You can take care of them. I said, run a business with
I
them.
mean, it takes a permit to run lots of things, right?
Yes.
Like you need a permit to run a sewage facility. Doesn't mean you don't own the sewage facility.
Our position on this is, once again, is that wildlife is different.
I'm saying, but you're just saying that, like,
Well,
why would
because
we
the
treat
statute-
wildlife different than every other type of property that people own and that can be seized in a criminal proceeding? And every other type of permanent property, right? I mean, there's many types of property that you have to have a permit to own.
Well, that's
And
true.
we don't say that the state can seize those without any type of criminal protections.
Well, actually, I don't believe it was without any criminal protections. Well, first of all, as I said, there is the upon conviction or sooner. So that right there, makes it different. Doesn't have to be a conviction. They do have their due process and protections by when the state came in, seized these animals and criminal charges were, filed, they could then, fight these in court, which they did. That's where their due process would be. So he decided to plead upon that point, and the statute is clear. Upon conviction, well, he pled, he knew it, he could have fought this in court, but he decided to take what was apparently a pretty good deal, getting out of the felony charges. And upon that, when he pled, it said,
So how long could the
They're
state have
forfeited.
waited? Could the state have waited 20 years?
I don't,
Because if they're not
And-
bound by the
and-
sentencing timelines, what, like, would there just be no timeline? I mean,
well, the statute
could the
actually,
state wait until, say, his kids sue to get them back on his deathbed, so it's 40 years later? It's an elephant, it's still alive, whatever, some animals live that long, there's birds that live 100 years.
well,
Can the state just wait till forever?
well, I can, first of all, the state is not going to, because they do have issues wanting to get these animals placed.
Okay,
But on the statute,
Fine.
yes, getting to your question, this statute, unlike the others, doesn't have a timing requirement in it.
So your issue is they could wait forever.
So yes,
Yeah.
actually, is what our answer would be. I don't think they're
But
never,
counsel,
they're
you
not going
agreed with
to.
Judge Mines a moment ago that this is not a criminal forfeiture, it's a civil forfeiture. Because you
That
agreed
is
with
what our
Judge
position-
Mines that this couldn't be a criminal sanction because the sentencing was done,
Yeah,
right? I mean.
we are under our,
So
that is what we believe this is. This is like any forfeiture with contraband, or like in the case I supplemented with,
forfeitures are civil proceedings.
yes.
Cite me to the rule of criminal procedure that allows, after 60 days after the imposition of sentence, that you can come in to the criminal court and have jurisdiction in that case. I'm not saying the circuit door, we're not here to address whether your client can get these animals. It's can they get them in a civil proceeding commenced in the felony case more than 60 days after the imposition of sentence. So you're essentially coming in and commencing a civil proceeding
Mhm.
supplementary to a criminal proceeding. I've never seen that. I was in a felony division for 5 years, never seen it, ever. I don't see any rule that allows it to happen. The case you cite
Yes.
in your supplemental authority points out that distinction, I think, very well. Can find the supplemental authority here.
I think what he's saying is it's gotta be a civil or criminal court. You're taking property. Right? It's like somebody's property, he owns this, you're taking it.
Here we go.
It's gotta be either civil or criminal. You gotta fit under one bucket.
In re forfeiture of the following property. This is the case you just cited in your supplemental authority.
Yes.
So in that case, Blanchett gets charged with a criminal charge.
Mhm.
Is a judge guilty, sentenced to 20 days in jail, given a fine, all criminal sanctioned, lost his hunting privilege for 3 years. Apparently that was part of what the trial court did at the time sentence was imposed. And that's end of criminal case. Then the commission, I think that's also, the parties are different. In a criminal case, there's state on one side of the V, and on the other, there's an individual name. It's in personam. In a forfeiture proceeding, it's in re, what I just said,
Mhm.
but then the underlying parties are the commission, not the state of Florida, not the state attorney for a particular circuit. And on the other side, there may be a defendant, but that's because they're entitled to notice in the in-rem forfeiture proceeding.
Yes.
So after criminal case is over, then your client commences forfeiture proceeding against the vehicle and the road. And lays out the argument, and then the circuit court in the criminal forfeiture proceeding denied relief in part. Court reads the two statutes, one, the criminal punishment statute, and then the one that they opine on is the forfeiture statute. And say, under the forfeiture statute, it's mandatory. And so on a direct appeal from the denial of relief, they reverse. They did not say what you seem to be saying is that by operation of law, the criminal court should have ordered forfeiture of these items They don't say that. And the agency here did not go back to the criminal court. And I want you to answer, wasn't that because the criminal court had no jurisdiction to entertain a forfeiture proceeding? But they go into civil court and they commence the forfeiture proceeding and do agree with your interpretation of this statute that it's mandatory forfeiture. The question here is, where, under the circumstances of this case, where the sentence has been imposed, 3800C is clear, gives the court 60 days. It's undisputed that didn't occur here. No motion to correct or modify, even setting aside defense argument that the trial court could have imposed a more onerous condition of probation by forfeiture of this private property. Let's just assume that could have occurred. It didn't, not within 60 days.
Correct.
So what allows to essentially reopen a criminal case and get civil forfeiture relief like the judge did here? You
What-
cite no cases in your brief. You cite no rules. These cases don't stand for that proposition in a criminal court.
That I supplemented with the Ford van case. That was strictly, actually, that was strictly just to show that under a wildlife setting, the forfeiture is mandatory. From what our reading of this is, the state.
That is,
FWC
meaning
did not
if the
need to.
court doesn't do it upon request by the state, by the commission like here, that it's error and it will be reversed on appeal if the judge doesn't do it because the judge was asked to and denied. The criminal court wasn't asked to by the state. That wasn't part of the negotiated resolution, was it?
Are you talking about in this case here?
Your case here.
In this case,
Mr.
no, it was
Lacudera,
filed.
that was not part of the plea.
Under our feeling is that it happened automatically. And as soon as that happened, since it was wildlife,
It
As soon as
happened
it's let it
automatically
in.
how? And so you're saying.
by operation of the statute, by
So
operation of 379,
So
338.
counsel, are you saying it automatically became part of the sentence?
We're
Because
saying
I
it's
didn't
not part,
understand your
we're
argument
saying
to
it's
that.
not part of the sentence. We're saying it's,
Counsel, I think
It's-
what he's saying is criminal courts don't just have roving random authority to seize property by operation of law,
correct.
right?
Yes,
Criminal courts have authority over a criminal case,
yes.
right? And it seems like there was a criminal case that happened and concluded. And then 6 months later, you all just file a motion saying, give us these animals. That would just be the criminal court reaching out for something that is not part of the criminal case. By your own admission, you're saying this is something separate. This is operation of law. Well,
We
if it's
don't
something
think this
separate
was
from a criminal
necessary.
case, it doesn't just automatically happen in a criminal case.
We actually don't think the judge needed to file that. At our office, we don't think that the judge actually needed to file this order. We think this order is actually just sort of messed things up a little bit, muddied the waters. We think it was already done. It's just that these FWC wanted to get disposition of these animals settled. So they were like, okay, we've got this other case. Let's at least get an answer from the court saying they've been forfeited.
So what you're saying is the animals change hands and the state can take property through forfeiture with no court order at all. And you guys.
Because the
just thought
statute
it was
says
simply a
shall.
Comfort order.
Because it's, yes, in effect, the statute says shall, so that means it
So-
is mandatory. It was already done.
But in this
Once he pled.
Henry forfeiture case, then why did they even go?
That wasn't wildlife, that was a Bavan. That's the
Correct, but the
difference.
statute said shall.
Right, we're showing it's under wildlife statutes, it's mandatory. That's all that meant. Shall definitely means shall under wildlife statutes.
Doesn't shall mean shall under all statutes?
Well, if you read that, if you actually read the case there, they go into shall juxtaposed to may. So
Yeah, but
sometimes
shall-
it
I
does.
said shall mean shall, right?
That's what I would say, yes.
But they still needed a proceeding to take the property in that case, right?
In the case of Van, yes.
Yeah, even though it said shall, they needed a proceeding.
Did,
Case said
in the
shall.
case of that, in that case, yes, since it was a van, since it was property. Once again, we go back to, this is what we figured out. It seems to be wildlife is different.
But all right,
That
but you
seems to
said it's
be it.
different because it uses the word shall, but the other statute uses the word shall too, so it's not different in that sense.
No, it's different because of the nature of what's being forfeited. Treating animals differently than treating
But that's
a
not based on the
van.
language of the statute, that's just you saying that.
No, well, it's actually this based. Shall being, it's done
But
either upon
most
conviction or
statutes use
before.
shall, counsel, that's
Mhm.
not unique to wildlife. There are other forfeiture statutes that say shall,
That's
so
true.
to say wildlife is different because of the use.
Not
of
needing the
shall-
hearing, though.
Don't interrupt me, counsel. To say wildlife is different because of the use of the word shall doesn't make any sense when other statutes use shall. What am I missing?
And I'm not explaining it correctly. That's
Okay.
not what I really meant. What I'm trying to say
Counsel,
is,
let me ask you this, and maybe this, if it's tied to Judge Meyer's question. So, plenty of statutes on the books about drugs, being
Yes.
illegal possession of drugs. There's a provision in that statute that says if you're upon conviction, your driver's license shall be suspended or revoked. Shall,
yes,
it's mandatory. But sometimes maybe I miss something. I'm the trial judge and I fail to pronounce, you lose your driver's license. Does it automatically happen anyway?
I would think so by the statute, yes.
Well, meaning if you're saying, can the Department of Motor Vehicles institute an action over here outside of felony court or the criminal court to suspend the license? I would agree with you, but I'm aware of no authority that would allow you, I've never seen a case where it would allow you to go back into criminal court more than 60 days later and say, Judge, you forgot to suspend the license. It says shall, you need to do it now.
Okay,
You have a case that says
no, I don't.
mandatory fines for trafficking offenses. Sometimes judge admits it. More than 60 days later, can the state come in and say, Judge, sorry, got to impose this $50,000 fine for the minimum of the trafficking? Can they do it?
No, that would be changing the criminal sentence.
Correct.
Whereas with the license, that would be, also an administrative function at the same time.
Because there's another place to go, either an administrative agency and maybe upon proper procedure to a circuit court in a civil case, right?
Yes,
Any authority that allows it to be done, yeah, in this case, the case jurisdiction of this criminal case.
I don't have anything other than that.
Let me use
Unless
the
you wanna say the court
restitution
retains
example.
jurisdiction.
Restitution example, the statute mandates restitution if there's a victim of a violent crime.
Yes,
Judge forgets. Can you come back more than 60 days later and get restitution?
no,
Let's say the judge orders restitution. Can you then come in later and say, we want to sue the defendant civilly so we can get some pain and suffering that isn't provided for in the restitution statute? Can you do that in the criminal court?
no.
That's what I'm struggling with, counsel. Question for us is not whether can your client get relief anyway. I think get relief where it did. And that's, I just, none of the authorities, but if there's something that I'm missing, please, what's your best case that help in
Other than-
this circumstance like this?
I don't have any other cases our argument was based on, what the statute said, that by operation of the statute, it was done as soon as he pled and was convicted.
I mean, we don't even know, we wouldn't be privy to it, certainly not in the record. That may have been part of the negotiation process of this plea, could it not?
No, in the plea, he says there's nothing else that they're reserving.
What I mean is like, hey, if this is what these are the negotiations, it's like, okay, my client will keep this, he'll plead to these misdemeanors, you're gonna drop the felony and the M1, and this is the deal. That could have been
Well-
negotiated, right? And we don't know.
Well, no, I mean, it's not in there, but,
Right, we know
the
it's
defendant,
just not addressed at all.
that's true.
It
It's
doesn't
not.
come up in the colloquy. I read the colloquy, it's not mentioned at all.
I agree, it's not. And I think it should have been. But the defendant, if he was disagreeing with what had happened, he missed his chance to appeal, and he
His
also
point
did
was
try
there
to.
wasn't anything to disagree with because it wasn't there. They didn't say in here, we're taking your animals. So there was nothing for him to disagree with. It's not like they said, we're taking your animals, and he had a chance to say, no, 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 that's not what I agreed to. The plea did not encompass taking the animals. He had no reason to object to a condition that wasn't part of the plea.
It wasn't even
Uh,
part of the factual basis. You stipulated the factual basis in the venue.
Well, that is true. But what I would say is, once again, our argument has to fall back on this statute, which is where we go to. It says shall as soon as he was convicted. And he knew what the statutes were, and he should have.
Could they do that in other instances? Like, could they say, you can take property or fines as a criminal conviction? Could they say, if you're convicted of this statute, you lose your house? And they don't have to, upon conviction, you lose whatever house you own, right? You can take properties as a criminal penalty, right? But because they said shall and upon conviction, the state doesn't have to include it in the plea or the sentence. And they don't have to sue you for it. They don't have to bring civil forfeiture. Just if you're convicted, they could not mention it in the criminal case and just send guys with guns in and take your house. With no court order, never having been mentioned in your sentence, and no civil forfeiture. Would that be constitutional?
Oh, that's sort of an extreme example
It's,
here,
it's
but-
literally the exact same example. It's not extreme at all. It's the exact facts of this case. It's just a house instead of wildlife. It's the opposite of extreme. It's like directly on point of what we have here. You have a criminal conviction
Mhm.
where property was not mentioned in any way whatsoever. And there was no civil suit to take the property. And your position is that at the moment of conviction, the state could just seize it with no court order at all. Other than the fact that one is a house or one is wildlife, and you could plug in any type of property, the facts are identical. It's not an extreme hypothetical. It's the exact facts of our case with a different piece of property.
Unfortunately,
Would that be
going by
okay?
I'd say going by the statute, since the statute does say that upon conviction, then he had better be very careful before he agrees to a plea.
So say just all your property, say, hey, if you murder someone, it could be a serious crime, so it's worth it. Upon conviction for murder, all property you own is forfeited. So guy pleads to murder, state doesn't mention it, property is not mentioned in the plea, it's not part of the sentence, there's no civil forfeiture action. State can just start going around the state, sending out armed law enforcement officers, take everything you own, no court order. This sounds proper to you. This sounds like a thing the state's allowed to do.
I would not say that sounds proper, no.
But all you're telling me is, well, with this statute, they can.
Mhm.
And the only thing you're telling me is that it's based on this word shall and upon a conviction. But you're telling me if that shall and upon a conviction language was used with any other property, that would be something the state clearly couldn't do, and it would seem really absurd.
If it's put in there, unfortunately, the state might actually start being able to do it if it's in the statute and you start agreeing to it. So
Well, that's my point. He didn't agree to it. It's not in the plea. So I'm saying,
if it's in the statute that he knows he's being charged with or is aware of and agrees to it.
yeah. So your
yes.
position is that's okay. So if someone pleads to a crime, statute says if you're convicted of this crime upon conviction, you shall forfeit everything you own. So same statute, just different property. Your position is, yes, with no court order, nothing in the plea, no criminal sentence, no civil case, state can just go around seizing everything the person owns. That's totally appropriate under the Constitution.
What I think is that this statute, which hasn't been litigated a whole lot, that is what it says. Whether or not the legislature needs to go and rework it, they might. That is what it says.
Okay,
In this case,
going to the you keep referring to the statute in the face of Judge Mai's question about the constitutionality. So let's set aside the constitutionality. Under the statute, it says if the animal, just use the short form, seized under the authority of this chapter.
yes.
I read the colloquy, I looked at the plea agreement. I don't even see a finding by the trial judge that these were in fact seized under the authority of this chapter, any other chapter, or rules of the commission. Didn't see it in the plea colloquy, didn't see it in the plea agreement. In the motion to suppress, the court quashed the warrant, so the warrant's out, can't be under the authority of the warrant. State stipulated to quashing the warrant.
Yes.
And then the court reserved on the issue of what would be suppressed and what was properly the commission made the alternative argument. We have an alternative argument, Judge, as to our authority. I don't see any findings by the trial court on that. You agree with that?
The trial court apparently accepted that because they didn't quash the animals they didn't say the seizure of the animals was incorrect. They didn't quash that.
But they didn't make it, the trial court didn't make a finding that they were seized under the authority of this chapter, did they?
Not that I know of, other than they didn't suppress the seizure of the animals. So the condition of the animals was admissible. There is a footnote
Correct. Yeah, the court did not suppress the evidence in terms of admissibility at the proceeding.
But I think that goes to the finding that they did have the alternative way to seize the animals. They had authority. He had gotten the licenses to possess those animals. And you agree when you get those licenses that your facility is subject to, inspection at any time.
So that
So
could
they
have
could go
allowed, had it been negotiated, that could have allowed perhaps your argument as the court could have imposed that as part of the probation. That would be your argument. Trial court could have done it, but didn't.
Yes, I think so. Other questions?
All right. Thank you,
All right.
counsel.
Well, then we would ask you that you affirm. Thank you.
So under the state's argument, a person is entitled to no process, no findings by a court, no notice, and a court has unlimited jurisdiction. The only time something happens automatic in a criminal case, as Judge White mentioned, is when it's noticed to the defendant during the plea colloquy, right? Because pleas have to be knowingly and intelligently done and voluntarily done.
Well, counsel, isn't that an overstatement? I was using specific examples. There are, in fact, like, for example, sex offender probation specifically says by statute does not have to be orally pronounced. It's automatically imposed, right?
Well, you have to notify the person that they are going to be a sex offender and the designation. And then when you go and report to probation, they enumerate all of that.
And the statute specifically says the court doesn't have to pronounce all of this litany of conditions.
No, it just has to inform you that this is your designation. And then your attorney has to explain to you this impact.
Do we have that here? Do we have any do you have any portion of these statutes that say without pronouncement by the court, the animals are forfeited?
Say that again, Judge.
Is there any provision of the statute that you're aware of that says the forfeiture of the animals upon convictions, it mentions upon conviction shall be forfeited? Certainly doesn't say there, even if it's not pronounced by the criminal court. But is there another place? Is there any other place in the statute that you're aware where it says, oh, this forfeiture word that's referred to over here, that happens automatically without pronouncement by?
No, and in fact, if you look at the preceding statute, 379.337 lays out the process procedurally for seizure and gives notice, procedure, all the requisite things that need to be done. I believe that it inures to the following statute that a process is necessary because nothing is automatic, right? Everything you are afforded due process. And in fact, this statute is a little vague, right? Because it says upon conviction. Conviction of what?
Counsel, can you address that or sooner language?
Yes.
What would be the process for implementing that upon conviction or the or sooner language?
Right, and that would be my argument that the preceding statute applies, where if you go through the forfeiture process, that can happen prior to conviction because
So you're
it's
saying it
separate.
need to be a civil forfeiture proceeding?
Yes. And so And then it says upon conviction or sooner. It doesn't say after, right? They put time specifications in it, although not specifically, it doesn't say after, but it tells you at the time, which is upon, and sooner. It doesn't say after, right?
Well, would it allow a criminal court as part of a negotiated plea and probation if the court withholds adjudication and nevertheless order forfeiture of the animals? That would be prior to conviction, right?
I would think that you can agree to that, but it would have to be implemented in a civil court.
Why?
Because
Where,
I
where,
don't
where
think-
does it say civil court? It says a court order if the court so ordered.
because I think that forfeiture is a civil procedure.
But it could be criminal as well, could it not? Are you
Well-
saying this statute prohibits the imposition by a criminal? I understand your argument about we're outside the 60 days. But let's say, are you saying that it would be an illegal sentence if your client would have added a negotiated term, I agree to forfeit all these animals? It's part of my plea.
You can negotiate anything, however, it's
Not
in
anything.
No, you can't.
Right.
Because then you can't-
All right,
You can't
most
negotiate illegal
anything.
sentences.
most anything.
But not really though, like you can negotiate a legal sentence, you can't negotiate an illegal sentence. So his question is would that be a legal sentence or an illegal sentence?
I think you can negotiate it, however, its enforcement is in a civil court. Because that's where forfeiture happens, right? You can
You don't think
agree
there's
to
any such
it.
thing as criminal forfeiture?
Well, for example, but what I'll back up and say, it's a different proceeding altogether, right? So for example, if you are arrested for narcotics and you have money as well. As part of the criminal case, they don't seize the money as well. You have to go through a different forfeiture where you're put on notice that they're taking that, and all that happens in a civil court. They put you on notice, there has to be evidentiary hearing, there has to be findings by the court, and then the court makes a ruling, we're gonna forfeit this or not. So, and I think that's what clearly didn't happen here. There was no
Oh, we
process.
know it didn't happen here, but.
No notice, and it was completely outside the jurisdiction, nor did this even apply to this type of case, this statute as a whole. Thank
Right.
you. We would ask that you grant relief for Mr. Lacudere.
All right, again, thanks, counsel, for your arguments. And that's our last case for the day. We will be in recess and adjourn for the day.